welcome everyone to this for IP Council webinar. Today we're going to be talking about infringing AI, liability for AI-generated outputs under the EU-UK copyright law. I'm Marta Sierra. I'm Head of Marketing and Communications at for IP Council, and I will be your host today. So for those of you who haven't heard about for IP Council before, I'm going to give you just a very brief introduction of what we do. We are a non-for-profit European research organization, and our research goes around the link between intellectual property and innovation. Our empirical research is done in collaboration with lots of different academics, IP experts, other European institutions, and we always make sure to choose topics that are relevant and current. Okay, if you go to our website, foripcouncil.eu, you will find all our papers under research. You will also see that we have case law summaries, that we have a podcast called IP Stories, where we actually had the pleasure of interviewing Professor Eleonora, our speaker today, very recently, and I invite you all to go listen to that interview. It was really great, and she gave really good advice to both creators and aspiring IP professionals. So I invite you all to go listen to that interview. And you will see that we also have a lot of recordings from previous webinars. So if this is the first time that you join a for IP Council webinar and you want to check the ones that we have done before, you can do so. We always record them, and this one will be available as well. So you will be able to find it from tomorrow on our website. We also have a section that is tailored to non-IP experts. So on our website under for SMEs, you will see that there are lots of interactive infographics, lots of content created for those that want to start learning about the different types of IP rights in a way that it's easy to digest and that I think is the best place to go to if you need to start from the basics. We also have a new area called IoT and cellular standards made simple. And here, if you want to learn about cellular standards, how they work, and the impact they had on technology across so many different sectors, you should come here, and we have videos, lots of different examples. So I invite you all to check it out as well. And if you want to make sure that you don't miss out on our content in the future and our upcoming webinars, you will find that you will find for IP Council the same handle in all of these platforms on X, LinkedIn, on YouTube, and Instagram. You can also subscribe to our newsletter. You will find the link on our website. And you can also follow our podcast on all the main podcast platforms by searching IP Stories. Okay, and without further delay, it's my pleasure to introduce our speaker today, Professor Dr. Eleonora Rosati. You will find her full biography on our website, but I'm going to give you a little intro about her. So she's full professor of intellectual property law at Stockholm University and of counsel at Bird & Bird. She also holds guest visiting positions at several other institutions. She's editor of the Journal of Intellectual Property Law and Practice, long-standing contributor to the IPCAT, and co-founder of Fashion Law London. She's the author of several articles and books on IP issues, and the most recent ones are Copyright and the Court of Justice of the European Union and Copyright in the Digital Single Market. She also has just published a new paper directly related with today's topic that you will be able to find together with the recording and the slides on our website. So before I give you the floor, Eleonora, just one final remark to our audience. You will find the Q&A tool at the bottom of your screen. You can use it at any point through the presentation. We will take the questions at the end of the presentation in the second half of the webinar, but you don't need to wait until then. You can send your questions from right now, and we will then cover them at the end. Thank you very much. And Eleonora, the floor is all yours.
Thank you so much, Marta. Thanks to you and for IP Council for inviting me. It is a pleasure to be here, and I would like to say hello to all the participants who are joining today's webinar. So indeed, I will be speaking for 20-25 minutes, summarizing what I think might be some of the main issues connected with potential infringing AI-generated outputs. And I would like to start with the image on this slide. You can see on the top left corner that there is a disclaimer that this is generated by AI. But I would challenge anyone who is in attendance to indeed recognize this as an AI-generated image and not an actual frame from the film Joker without this disclosure. And this image has been generated through an AI model. It was discussed in an article of the New York Times in early 2024. And I think raises some set of novel questions that the advent and the development of generative AI does pose. So indeed, the past few months have been all a series of headlines about developments in generative AI. And it is a history that is already quite dense, but is also a very recent one. And indeed, this first article that I'm sharing dates back to June 2023. It seems several ages ago, but at the time, ChatGPT had just recently launched and already was attracting some questions under intellectual property law. Then there has been indeed concerns expressed by authors whose works have been used to train these AI models. There has been indeed lawsuits being filed by them in different parts of the world, with currently several lawsuits pending in the US, as well as a couple in Europe as well. Scarlett Johansson, the actor, has already featured in the AI debate not once, but at least twice, in connection with the use of her likeness, as well as the use of her voice, as you can see here. Then in between, as you could see, I shared the news of the New York Times taking legal action for copyright infringement due to the alleged unauthorized extraction and reproduction of content from the New York Times paywalled website. Then there have been indeed developments in Europe. The AI Act has been adopted, and these might have, together with data protection, privacy laws, created some questions of compliance for many generative AI providers and developers, and then these cases that are still pending. So this is just an overview of some of the events that have occurred over the past several months. Now, if we move on to the dimension of copyright as applied in the generative AI field, I would say that with a simplification, it might be possible to divide two key moments: the input training stage and the output generation stage. Insofar as input is concerned, of course, and that is proved by all these lawsuits, the big question mark is around the lawfulness of training of AI models without a license. This boils down to the question of fair use in the United States, whether and to what extent this doctrine can be applicable in these cases. And here I would like just to note that fair use is, like many other like all the other defenses, but perhaps even more than other, very fact specific. In Europe, there is the question of text data mining. As you know, the European Union has adopted now 2 mandatory exceptions for text data mining. There are countries like the UK, which legislated independently back in the past. The UK exception was introduced indeed in 2014. And then around the world, there are other countries that have also legislated, the first one being Japan, Singapore, and now a potential TDM reform is being discussed in a country like Hong Kong. Insofar as the output phase is concerned, the main focus of discussion, and perhaps the first discussion appearing around the generative AI and copyright, has been the protectability of these outputs. Also here, as you know, there is some case law that has emerged already, both in the US and in Europe. I'm referring to a recent Czech Republic case, and in China, with indeed a case decided a few months ago by the Beijing Internet Court. What, however, seems to me that is not yet risen to the fore as it should is questions of liability related to these AI-generated outputs. There is, I think, little doubt that in some cases, AI models not only reproduce third-party content, but memorize this content, and if appropriately prompted, can generate images or other types of content. I'm thinking about audio, but also video, and text that resemble the input data. And indeed, here is a couple of examples that I've generated myself by using some AI tools. The first one is the result of a prompt that I gave to generate a video game plumber in the style of Mario from Nintendo. And the second one is a prompt that I gave to create an image of singer-songwriter Dua Lipa. I mean, we can have a discussion whether this actually looks like a Dua Lipa, but clearly it looks a lot like her in terms of appearance, of the face, haircut, and also fashion style. So all this triggers the question under copyright, but the discourse clearly goes well beyond that. And indeed, it covers, as in the case of Dua Lipa, questions of image and publicity rights, the reproduction of one's own likeness, and as I will show also at the end, questions of potential relevance under trademark law. And then, of course, there are aspects connected with data protection and privacy laws as well. That said, I think that from a copyright perspective, there might be three questions to address at the outset. The first one is whether these images that I've shown to you, but the same would apply in relation to any type of content, whether it is audio, video, or text, whether this resemblance that in technical terms can be called a plagiaristic output is actionable under copyright and related rights? And the answer is yes, provided the relevant requirements are fulfilled. This, of course, is an answer that should not surprise anyone. But if this restricted act is found to have been performed, who should be responsible for that? An instinctive response might be it is the user who inputs the prompt, resulting in the potential infringing output that should be solely liable. But I find that this response, while it might be appropriate in some cases, would be an undue simplification in many others. And indeed, in light of existing case law, at the EU level, I'm referring to the Court of Justice, but also of UK courts, it is possible to envisage, at least in certain situations, a potential responsibility and therefore liability also of AI developers and providers. And then the final question that I would like to address is if a prima facie infringement is found to have been committed, are any exceptions or defenses available, and if so, who can benefit from them? So in a nutshell, these are the three questions that I would like to respond in the to answer in the time at my disposal. So let's start with the first one. Here we're speaking about the right of reproduction. It is still a very relevant right under copyright and related rights. And if we look at the international dimension, if there was a need for that, but also abundant case law, it is clear that this right applies also in a digital environment and therefore also in an AI context. Here, the point that I would like to stress is from a European UK perspective, it is clear that if we consider the input training phase and then the subsequent transition to output generation, we have multiple acts of reproduction that are being undertaken. There is a reproduction done at the training level by making copies of works that are necessary to train an AI model. And then if there is a plagiaristic output, this might be considered a reproduction at output level. So it is important to note that if we look at the existing text data mining exceptions, here I'm focusing on Europe, but very similar discourse can be done for other jurisdictions that have introduced specific TDM defenses, is the circumstance that the scope of application of these defenses is limited to the first act of reproduction, the one occurring at the input training phase. So the EU defenses, as well as the UK one, cover acts of extraction and reproduction that are undertaken in this moment. They do not cover subsequent reproductions. So the defenses will not extend to outputs that contain an actionable reproduction. Second point that I think might be worth clarifying, and I suspect I might be controversial to some of those in attendance. As you know, there is right now a big discussion whether text data mining defenses actually are even meant for artificial intelligence, because they were drafted in 2014 for the UK, in 2019 for the European Union, and AI back then did exist, but it looked very different from how it is today. In my view, this discussion is flawed and likely has very short legs. First of all, because I believe that even at least for the EU dimension, the link between text data mining and AI was already understood back then. There are commentaries by scholars that clearly referenced the relationship between TDM and AI. There were reports prepared at the request of national governments, and now with the AI Act and the reference to indeed Article 4, among other things, of the DSM directive, in my view, this discussion has been put to rest. But nevertheless, it is important to outline how indeed the TDM provisions do not cover any possible restricted uses. Then the third point relates to the AI Act. As you know, this is a regulation, so not specific copyright legislation, but nevertheless, it adopts an approach in its Article 53 by which all the steps in the training and then subsequent offering of an AI model in the European Union need to comply with EU law, including EU copyright law. So that in turn means that if the training of an AI model through text data mining is performed lawfully in a third country jurisdiction, once the AI model is brought and offered in the European Union, this lawfulness of TDM might indeed be superseded by the requirement of complying with EU law. So we can have a discussion whether this approach is appropriate or not, but on a legal level, I would note the following. The first one is that this provision will apply, in my view, not only to new models that will be brought to the European Union after the full entry into force of the AI Act, but also to subsequent updates and upgrades of these models. And the second point that I would like to make is that this might seem like an extraterritorial reach of EU law that goes well beyond a Brussels effect as understood in policy terms. But this is not an approach that is unprecedented, and it is also compatible with the case law of the Court of Justice, which indeed has often adopted a functional view of the doing of restricted acts, with a view to consider the relevance of the intended final result. So, to conclude on this first point, I think that it is important to clarify the limitations of existing TDM exceptions. Turning to the right of reproduction, and here I will be brief, there is a distinction to be drawn between copyright and related rights. Insofar as the former is concerned, as we know, copyright is premised on an originality logic, and the test of actionable reproduction is unsurprisingly found in the landmark decision in InfoPac from 2009. And there, the Court of Justice did clarify that there is an actionable reproduction when what has been copied is indeed an original part of a work. So the right of reproduction is broadly phrased. It also applies to parts of a work. And importantly, it does not only apply to verbatim copies. So the Court of Justice seems to suggest that the copying may be also in an altered form, so what technically might be even an adaptation, and still be actionable. For related rights, I think that the discourse needs to be even more careful because the traditional view of related rights, whether one likes it or not, is that they are not subject to any threshold conditions, so they are different from copyright. Now, in the European Union, there has been a decision in Pelham concerning the reproduction right of phonogram producers. And in that case, the Court of Justice adopted what I think is unquestionably a very peculiar approach to determining actionable reproduction by making it subject to a recognizability logic. I'm not sure that this approach should extend to situations other than those in which we have a phonogram producer's right vis-a-vis third-party freedom of artistic expression. And in any case, I find the guidance of, in particular, Advocate General Spooner, in his opinion to the case, particularly helpful. He anchors related rights to an investment logic. So even if one was to deny that there are no threshold conditions, it might be possible to adopt an investment logic so that what is actionable is a reproduction of an element that reflects the investment of the related right holder. But here, once again, I would like to stress how the right of reproduction goes very far, and indeed it is relevant to an originality logic or an investment-based logic if one does not want to indeed accept a situation of no threshold conditions. Having said that, and so having pointed out how these outputs can contain actionable reproductions, the second question is who could be potentially liable if that was the case. And I think that in this respect, we can identify three main actors. The first one is the user inputting the prompt, resulting in the infringing output. Now, I would like to just note that there are many AI model providers that have included certain filtering systems in their models so that it is not possible to use certain words, etc. But this will not remove the potential responsibility of a user. But I think that it might be also possible to envisage, at least in certain cases, a liability of the developer or the provider, or both of them. I'm aware that in the AI Act, these two roles seem to be conflated, but I would imagine that in some situations, these might be different entities. So even though the terms of use of an AI model would vest the user with any liability resulting from the outputs that are generated, I would imagine that in certain situations these terms would be unenforceable, ineffective, or even in some situations invalid. And the reason why I'm saying that is because there has been, on the one hand, a tendency on the side of EU and UK courts to pierce the veil of lack of responsibility of these entities vis-a-vis users. And indeed, those of you who specialize in copyright will promptly recall that in many situations, the Court of Justice, but also UK courts, have found the liability to subsist on what in the past might have been called intermediaries. And the second point is that even if the terms of service vest all liabilities, if any, on the users, this might not be enough to exclude the liability of the AI model provider. And here I would like just to cite one decision, that is the judgment of the Court of Justice in the YouTube case. and specifically having regard to the cyberlocker uploaded, the Court of Justice noted how the circumstance that terms of service will prohibit users from infringing copyright, this might not be enough to remove any risk of liability. In the resulting judgment on the merits in Germany, the liability of uploaded was indeed established. So it is a multi-factor assessment, but also those who indeed provide and develop AI models should be wary of the potential risk associated with certain types of outputs. Then coming to the final point that I would like to make is the applicability of defenses. And in this sense, I would like to start by noting that all defenses under both international and national law, as well as regional, are subject to the three-step test. We can have a discussion who the addressee of the three-step test is, but I feel quite strongly that it is not just national legislatures, but also courts at the national and, insofar as the Court of Justice is concerned, regional level. And if you take even a jurisdiction like the United Kingdom, in which the three-step test is not part of the statute, you find a case law that does mention the need to consider the three-step test, so that it is not precisely something that is flattened on the traditional notion of fair dealing. So the three-step test does matter not only to construe text examining exceptions, as it is clearly stated in the DSM directive, but it matters also for exceptions that might be potentially invoked at output generation. And in particular, here, something that I would like to throw on the table for you to reflect upon is what relevance the lawfulness or lack thereof of the source has for the potential eligibility of an exception. There is case law of the Court of Justice that does indicate that if the source of the user's own reproduction, for example, is unlawful, any defense will be unavailable to that user. That is the case, for example, of quotation. It is written down in the EU legislative text that among the conditions that need to be satisfied, there is also the lawfulness of the publication that has been quoted. So, having said that, I would like to indeed emphasize the importance of these three-step requirements and the fact that it should not be overlooked when we construe relevant exceptions. Now, coming to some that might be applicable, I've already mentioned quotation. It is subject to a series of cumulative requirements under EU law as well as national law. Among them, there is the lawfulness of the source that is being quoted. Of course, quotation is not limited only to parts of a work. It can, in principle, encompass a work in its entirety, but once again, subject to the requirement of the three-step test. Pastiche, a brief mention on that. It is an exception that without much doubt for a very long time was considered a minor exception in a copyright law. The case law on pastiche is still very limited, and now, however, it is at the center of a pending referral to the Court of Justice, Pelham 2, so we will have guidance from the EU Court on that matter in the near future. It has been also already applied in some national case law, including in the UK. Those of you following from the UK will promptly recall that in Shazam, the defense was considered but ruled out. So, what is the relevance of pastiche? I think that first, the fact that there is a defense for pastiche, which is the imitation of one's own style, should make us pause for a moment regarding the very swift statement that one could make that styles are not protected in copyright law. If that was true, then this exception would be ridiculous to have. The fact that pastiche does exist shows that when we speak about styles, we need to be careful in applying the idea expression dichotomy, a cornerstone of copyright law, too swiftly and without much thinking. What I always say to the students I teach to is that the word dichotomy suggests a simplicity that I wish was there, but is not always there. Something that is dichotomic is black or white, square or circle, but the reality is that it is more like a spectrum in which there are things that are clearly unprotected ideas and things that are clearly protected expressions. But for styles, it is an ambiguity that sometimes make one style fall on the idea side of the spectrum and in other situations on the expression side. Let me exemplify it by reference to the image that you see on the slide. These are, once again, AI-generated images in the style of Marc Chagall. You might be surprised, but Chagall's work is still protected by copyright because indeed he died in a very advanced age. So is this just a style that is unprotected, that is being reproduced? Personally, I'm not sure. So this will be a case in which I will see the relevance of discussing pastiche. While the Court of Justice for sure will give us guidance, I would like to emphasize the following. The first one is that clearly pastiche is an autonomous concept of EU law, so there is no room for national legislatures or courts to define their own concept of pastiche once the Court of Justice has ruled. But another point that I would like to make is that I do not see pastiche as having broader scope of application as, for example, parody or caricature. These are exceptions that apply to different fields, but do not have a different scope. And in any case, also pastiche is subject to the three-step test. So once again, we shall see. So coming to a conclusion before addressing any comments or questions that you might have, I would like to note the following. Insofar as the input and training phase is concerned, text determining exceptions are for sure there, but their scope should not be intended as covering the doing of any potentially restricted act under copyright and related rights. They cover specifically defined and clearly indicated exclusive rights that concern activities done at input training phase. Insofar as the AI Act is concerned, its relevance should be borne in mind by anyone who develops and puts on the market AI models, because indeed the compliance with EU law might lead to certain specific strategies, considerations, and potentially compliance exercises. Coming to actionable reproduction, the test differs between copyright and related rights, but nevertheless, the scope of protection is broad in both cases because this is written down in the law and it has been relied upon in the case law of courts, including the Court of Justice. When there is an actionable reproduction, the liability might vest with the user, but might also extend, in certain cases at least, to developers and providers of AI models that are used to infringe. Last but not least, insofar as exceptions are concerned, they are all subject to the three-step test, and something that I did not mention, but I think might be worth stressing, is that these exceptions entail protection of freedom of expression, quotation, parody, pastiche, they are all freedom of expression-based defenses. And the Court of Justice tells us that there is the need to enter into a dialogue with the earlier work or author to enjoy these defenses. So I think that the only entities that might be able to invoke these defenses successfully will be the users, because it is the user who generates content that might do so with the intention of entering into a dialogue. To conclude with an example, if I have generated the images that you've seen in this presentation and I've used them for the purpose of indeed illustration, criticism, or review, then I can see that I have performed a dialogue. But if I generated these images to sell them on the internet or to exploit them commercially, so outside of a review context, then I'm not sure that there will be this dialogue intention on my side and therefore the possibility to enjoy protection under these defenses. And to conclude, I would like to show you one final image. It is once again AI generated. Here the prompt was create an image of Emily in Paris from Netflix. As you can see, the resulting image might not look exactly like Lily Collins, but the look and feel is very similar. It is the image of a young woman with dark hair, long hair, with some waves, and certain facial features. So clearly there is an understanding of how Emily in Paris does actually look like. And I would like to note that both Netflix and Emily in Paris can be protected trademarks, as I'm sure that they are. So there is also a question on the IP side that involves trademarks and not just copyright related rights and rights over one's own image or indeed likeness. And with that, I would like to conclude and thank you for your attention. If there are any questions or comments, I will be more than happy to take them. Thank you again.
Thank you so much, Eleonora. It was great, and we have received actually lots of questions. So I'm gonna go ahead to try to make to go through as many as possible. So the first question says, your presentation covered an EU-UK perspective. Would the analysis differ under other copyright laws?
But thank you for this question. I think that the answer is broadly in the sense, not necessarily. So of course, I've mentioned the case of the United States and the open-ended doctrine of fair use, and like there, also in Europe, each case will need to be assessed on its own merits. So it will be erroneous to draw indeed too swift conclusions. But I find that it is a risk to think that there are jurisdictions that are necessarily more permissive than others. And also now with the approach taken in the EU AI Act that seems to impose compliance with EU law, irrespective of where one is based, I think that also on a commercial level, there will be a decision that needs to be made regarding whether it is wiser to comply with EU law, so to follow what might appear as stricter requirements, or decide to opt out of a market of 500 million people that is indeed interested in using these AI models. So I find that there will be in the long run a level playing field, given indeed this rush to regulate that is happening first in some jurisdictions more than others, but overall likely to lead to a result that is quite homogeneous on a global level. I'm not sure whether this view is too optimistic, but I see that this might be a direction already taken in this sense.
Mm-hmm. Yeah, makes sense. Okay, another attendee asks, is it true that the styles are not protected? I heard that it's never an infringement to create something in a style of a certain artist, but I think we might have seen that in the presentation.
Yes, I would like to stress once again that it is too simplistic to say that styles are never protected, because if that was the case, the defense for pastiche would be completely senseless. The fact that it is there, I think, suggests otherwise, and indeed there is also case law that has recognized how well developed and detailed ideas verge on the side of protectable expression. So let's be careful to say that styles are never protected, because that is simply untrue.
Okay. Okay, here's a quite generic question, but hopefully you will be able to answer. It says, in sum, what is the way forward for generative AI development?
Can you repeat this question?
Sure. It says, what is the way forward? In sum, summarizing, what is the way forward for Gen AI development?
But way forward, I think that one needs to make an assessment of the potential risks associated with training an AI model on copyrighted content without a license. That is a perfectly defensible choice, but it might come with very significant risks. So, as I hope I have shown, these TDM exceptions only cover part of the copyright relevant acts. So probably these should inform reflections on the side of right holders, but also generative AI developers and providers, whether the way forward might be more of a consensual solution in the form of licenses and the likes. We can discuss what types of licenses, but I see that as things currently stand, only relying on exceptions might turn out to be risky in the short or even medium term.
Mm-hmm. Okay. We have another question. It says, can the question of liability over AI-generated content be bypassed by contract terms? For example, terms between a user and an AI provider, or a creative agency creating content for clients using AI?
But of course, the contractual part will play a very significant role, but there is case law that shows how indeed in some cases terms of service might not do the trick in each and every case. So it might not be enough to say you are liable, I'm not. So also here it is a multi-factor assessment that will need to be undertaken, but the case law already tells us this. This insofar as the relationship between generative AI developers, providers, and users. And then, of course, there is the relationship between these entities and the owners of earlier rights. And this is something that, as I mentioned, could be also addressed from a licensing perspective even before the training is undertaken.
Okay. And another question says, the AI Act seems to go beyond the classical Brussels effect. What are the broader global implications of this approach?
So this is something that in different shapes we have already seen, no? And I would probably date back the start of this Eurocentric wave to the GDPR in 2016, no? And we know that compliance with the GDPR on a global level turned out to be quite a complex endeavor. Then in copyright, we focus on 2019 and the DSM directive, and here in particular I'm thinking about the regime for online content sharing service providers in Article 17. Also there was some sort of targeting approach employed by the EU legislature that was matched by the subsequent approach in this sense in the Digital Services Act. No matter where you are based, if you target the European Union, you need to comply with EU law. Now, the approach in the AI Act is different from targeting, but reinforces this idea that EU rules apply also to non-EU entities. And on a broader level, I would say that this strengthens a reflection on who is actually setting the rules for technological advancement on a global level. If I think about the beginnings of the internet and its regulation, a lot of that came from the United States. Let's think about Section 230, the Digital Millennium Copyright Act, and then this model was adopted in one way or another by many other countries around the world. Now, over the past several years, the discourse seems to have shifted to the European Union, and we find that many of the European approaches are discussed, contrasted with, but they are part of the discussion in other hubs around the globe. They are present in Australian reform discourses, in US Copyright Office studies and report, Hong Kong reform of text data mining, the potential inclusion of a TDM provision also in China. So it is something that speaks in favor of a center stage of the European Union, whether one likes it or not. And as I mentioned, these might be well beyond a political influence, a Brussels effect, and have a very concrete implications for those who want to develop and offer these services, thinking of the world as a global market. IP rights are territorial, but there is an ambition of the European Union to extend the EU approaches also outside of this region of the world.
Okay. Okay, we are receiving loads of questions, so I'm going to try to go through them. Another one that is very interesting, what do you think of the Court of Justice in the European Union? What do you think the Court of Justice of the European Union will say regarding the notion of pastiche when it decides Pelham 2?
Okay, so thank you for this question. If I had to attempt a response, I would say that the Court of Justice will stress, as I mentioned also during the presentation, the autonomous character of pastiche, and this in turn will remove the possibility for individual member states to keep their own definition of pastiche and possibly have to adapt to what will be the CJU mandated definition. Then I think that the Court of Justice will adopt a definition that is in line with the everyday meaning of the concept of pastiche. It has done that in the past for many other exceptions and concepts in EU copyright law. So probably there will be references to the dictionary definition of pastiche. And probably there will be also some limits that will be imposed by the Court of Justice by reference to the three-step test, the fact that a pastiche to be lawful needs to have an intention to enter into a dialogue, and probably, like it has happened with parody, there will be indeed a mention that not every type of pastiche will be considered lawful. On this note, however, I would like to note the following: that DECMIN, the parody case, was prompted by a factual background in which the use at issue had clearly discriminatory tones. This is not the case of Pelham. So there might be a reference to this, given that DECMIN is the most immediate case to reflect upon. But if that is not the case, clearly it will be deductible from this jurisprudence in the event that there was a pastiche with a derogatory, discriminatory character.
Okay. What do you think of the fact that Gen AI developers, providers, implement filters that prevent the use of certain prompts?
So there are various angles from which this matter can be considered. No? On the one hand, the use of these filters might be mandated in the future by legislation like the one that can take shape through the AI Liability Directive. There are commentators who have already indeed noted how the use of these filters might be mandated by law in the future. There might be also indeed an aspect of a diligent economic operator, a standard that the Court of Justice has been endorsing for a very long time in different fields of intellectual property. But from a more commercial standpoint, it has been suggested, not by me, but by others, that the fact that these filters are being implemented might also indicate on an evidentiary level that the training has taken place on content of a certain kind that indeed one does not want to be reproduced at output generation. So to conclude, there are several potential angles from which the question of filtering can be considered. I would like also to note that filtering is nothing new in EU IP law. The most immediate precedent is indeed the so-called upload filters from Article 17 and the guidance that the Court of Justice has given in that respect. The CJU in the Poland case has indeed set some boundaries for the lawfulness of automated content recognition technologies, and in future potentially contentious cases, this guidance might turn out to be helpful once again. Oh, you're muted now, Marta.
Sorry about that. Okay, so the next question says, your focus has been on copyright, but what other areas of the law can be engaged when we speak about types of outputs, about the type of outputs you have discussed?
Mm-hmm. So, as I mentioned with the final slide, there is clearly a potential trademark angle as well, and this is something that has been raised in some of these generative AI lawsuits cases. So it will be interesting to see how courts approach this aspect, whether there is a use as a trademark, whether this use is actionable, whether a defense applies, etc. But I find, to go back to the examples of Scarlett Johansson, but also the output that I've generated using Dua Lipa in the prompt, that clearly image and publicity rights are an important part of this discussion. And the thing to be noted is that these rights are virtually unharmonized on either an international or regional level, unless one wants to indeed approach these issues from a data protection perspective, and then there might be some harmonization, but the bulk of it is unharmonized. So I feel that this might be an area that will call for some harmonization reflections, for example, at the level of the European Union. This might be a topic for which these discrepancies that we see across different member states might really create an internal market problem. Because in Europe alone, we range from countries where image rights do not exist as such. It is the case of former EU member state in the United Kingdom, but it's also the case of Ireland, to countries in which image rights protection is not only recognized, but is also very broad. If I take Italy, courts in Italy recognize post-mortem image rights protection and recognize image rights in products of Italian cultural heritage, such as Michelangelo's David, so not only persons, and they say that these rights are actionable even in cases of mere evocation without even the use of someone's own image. So I find that this discrepancy creates an internal market problem in this context of generative AI, so I feel that it might be quite urgent to decide whether harmonization should be pursued.
Okay. Could you please clarify whether, in your opinion, the exceptions will likely apply in terms of training an AI model, but not in terms of using output?
Mm-hmm. So I find that the text data mining can be applicable in some training scenarios. Again, as I said, there is right now a discussion that I don't know how helpful is it, but there is a discussion out there regarding whether TDM exceptions were designed or not with AI in mind. I find that they are applicable also in an AI training context, but they do not extend beyond this training phase. So if there are other exceptions that are available, they are not those for text data mining, and we need to look into quotation, pastiche, parody potentially, caricature, and so on, but not text data mining. And that is something that is banal, but is not always promptly indeed stated as it is. These are exceptions that only cover the doing of certain specified restricted acts.
Okay. So many questions coming through. Okay, great. So here's another one that it's a little bit related. Do AI developers need to disclose which copyright materials they have used for training?
But that is a big question. The AI Act does impose a transparency requirement. There will be a template that is developed and made available by the newly established AI office. So the law speaks of a sufficiently detailed summary, but once again, we will need to wait and see what that means in practical terms. Of course, it is clear that if the training has taken place on several millions of works, having to provide an indication of each and every of them can become a very burdensome type of compliance requirement. So I will not pronounce myself in one sense or another. I think that we will need to wait and see what template is actually being developed by the AI office.
Okay. All right. So in the text data mining exception, lawful access to the work means that the developer must sign licensing agreements with the authors whose works are used during training.
Not necessarily. So in essence, it depends on the status of these works first and foremost, because if the works at issue are no longer protected by copyright, then unless there is a moral rights angle, and in some countries moral rights are perpetual, then it is not that licensing is the only way to go. But assuming that most developers are interested in copyright works for several reasons, when it comes to text, because that is the language that is currently being spoken, when it comes to music, because there is the need to cater to contemporary taste also of music listeners, then yes, licensing is one way. Then there are situations in which, for example, someone has decided to renounce their copyright through a CC0 license, for example, of Creative Commons. So to answer that, yes, I would say that in many cases, this would entail licensing, but not necessarily always.
Okay. And although we don't have a lot of time, I want to go on with the last question. What do you think users of AI tools, like creators, should think about to avoid legal risks?
But the boring answer is they should read the terms of service. But I understand that this might not be realistic. So in a nutshell, if it, I would say rule of thumb, if it is someone creating an AI generated image for no commercial exploitation reasons whatsoever, to review the style of someone, so to engage with that content, it is likely that they might be able to reduce the legal risk. But for anyone wanting to use AI in a commercial context, then they should be reading the terms of service and also understand very well if there is any liability, who is gonna hold it, whether it is the provider of the model that they are using or whether it is the user themselves. And I think that here, despite some headlines regarding protection of users, many of these terms of service might be quite protective of the providers of these tools, but not the users thereof. So if you are thinking of using AI for commercial exploitation purposes, professional purposes, etc., then this reading is something that I guess you should not be escaping.
Okay, great. Well, we are reaching the end, I'm afraid. We could go on for hours or days because we have so many questions, but I'm afraid we have reached the time to conclude the webinar. First of all, Eleonora, thank you so much for sharing your...
For having me. What I wanted to say is, of course, if there is any participant who would like to continue this discussion offline, they are very welcome to contact me by email or on LinkedIn. So there is absolutely no problem in this sense. So thanks so much, everyone, and to you as well.
That's really, really generous. Thank you so much, Eleonora, and thank you for sharing all your knowledge and your expertise with us. So before we go, I just want to say a couple of things. The recording of today's webinar will be available on our website tomorrow, together with the slides and as well the paper we mentioned before. So if you want to dig a little bit deeper into this topic, I invite you to read Eleonora's paper as well. We also have already available for registration our upcoming webinar. It's called IP and Startups, What, Why, How. You can scan the QR code on your screen, or you can go to our webinar section on the website. It's happening on the 24th of October. And finally, you will receive a very short survey, just 1 minute, to tell us how much you liked the webinar and also give us suggestions on future topics to cover. So again, thank you so much, and I hope you all have a great day. Bye-bye.
Thank you everyone. Bye.